Hello, all the aspirants of UPSC 2023. Welcome to the RAO'S Academy for Competitive Exams, Bhopal and Indore. And I would just like to say one thing, that I'm sure you're preparing well for your exams, because if you fail to prepare, then be prepared to fail. So today I have brought across polity papers, previous year's questions. I have randomly picked out some important questions which I feel are important in the context of today's polity. And we will be discussing each question in detail, how exactly to approach these questions and how to reach the correct answer. I am Aruna Mohan Rao, 1987 batch I.P.S officer. And so here we go. The first question that I've picked up is, an amendment to the Constitution can be initiated by an amendment. Very important topic for your polity paper. It can be initiated by the Lok Sabha, by the Rajya Sabha, state legislatures, or by the president. These are the options that have been given. So you know that an amendment procedure is under Article 368 of the Constitution, Part 20, and the procedure has been elaborated in this particular article. So the answer to this question is that it can be initiated in either house of the parliament, either in the Lok Sabha or in the Rajya Sabha. So the answer here will be 1 and 2, and your option will be D. So an amendment to the Constitution can be initiated in either house of parliament. It cannot be initiated in either state legislature or a state council, and also not by the president. An amendment does not need the prior approval of the president to be tabled in the houses of the parliament. It can be introduced either by a minister or a private member as well. It has to be passed by a special majority in each house separately, by a special majority in the Lok Sabha, by a special majority in the Rajya Sabha. And by special majority, what do you mean by special majority? Is that there should be a majority of the total membership of that house, and the members who are present have to, by 2/3 majority, have to pass that particular bill by all the members present and voting. That is called the special majority for any particular bill to be passed. So there is no provision for a joint sitting for an amendment bill. Whenever there is a dispute, there is no provision for any joint sitting. And when a bill is passed separately by both the houses, it is sent to the president for his assent. And here the president has no option but to give his assent to the amendment bill, because it has already been passed by a special majority by both houses of parliament. He cannot withdraw the bill, nor can he send it back for recommendation of the parliament. So that way it becomes, once the president gives his assent, it becomes an act, a constitutional amendment act. So the amendments can happen in 3 ways. One is by simple majority of parliament. There are a few sections of the constitution which can be amended by the simple majority of the parliament, that is a 50% majority. Then by a special majority, as I said, majority of the house and 2/3 majority of the house members present and voting is a special majority. And also there are some sections in the constitution which need a special majority of parliament, as well as the ratification of half the number of state legislatures as well. And the state legislatures have been given no time limit to give in their ratification for some particular sections of the constitution, which can be amended by both the parliament as well as the state legislatures. So I hope this question is clear. If there is any question on Article 368 relating to amendments to the constitution, we have to know all these particular aspects of the process. We go to the second question. Consider the following statements about the recent amendments to the elections laws by the Representation of People Act 1996. Okay, so there is there have been a lot of changes, lot of amendments, lots of procedural changes which have happened for the election process in our country. So we have to be very clear about what are the constitutional provisions and what are the other provisions regarding to elections which are conducted regularly, which are actually the backbone or the heart of the democracy in any country. And India has become a very vibrant democracy because we are having elections regularly, and we have always been amending our procedures so that we have fair and free elections every time, whether it is for the parliament or for the state assemblies. So consider the following statements. Any conviction for the offense of insulting the Indian national flag or the Constitution of India shall entail disqualification for contesting elections to parliament and state legislatures for 6 years from the date of conviction. And if anybody is convicted of this particular offense, they can be debarred or disqualified from contesting the elections. There is an increase in the security deposit which a candidate has to make to contest the election to the Lok Sabha. There is a particular amount of money that they have to deposit. A candidate cannot now stand for election from more than one parliamentary constituency. A candidate cannot now stand for elections from more than one parliamentary constituency, and no election will now be countermanded on the death of a contesting candidate. So these are some of the options that have been given. You have to examine all of them very carefully before you reach the correct answer. So here the correct answer will be that 3 is wrong. This statement is wrong. So your first statement is correct, your second statement is correct, and your fourth statement is correct. So see where you have those options. The option will be B. 1, 2 and 4 are correct. Your option C is wrong. The candidate, he cannot be allowed to contest for more than 2 constituencies, 2 Lok Sabha. This is not 1, this is 2. So that will be the change. So that's why this particular statement will be wrong. So you have to eliminate you have to eliminate which is the wrong answer, and if you know that these are the correct answers, then you can automatically reach the correct answer. So in India, to ensure free and fair elections, we have had a lot of changes. So Article 324 to Article 329, they elaborate on how the election process will take place in our country. So now we have an election commission, as you all know, a very powerful constitutional body which is conducting elections very regularly, ensuring that the elections are free and fair and not bereft of all kind of corrupt or disruptive practices. So Article 324 of our constitution, it provides for the establishment of the Election Commission of India, which came into force on November 26, 1949. November 26, 1949. This was the date when our Election Commission came into force. So the Parliament has elected Representation of People's Act in 1950 and also in 1951, that is before we had the first general election. So we already had the process of ensuring that the elections are going to be free and fair. So in Article 324, we had the establishment of the Election Commission. In Article 325, we have the provision of universal adult franchise, where you have people voting for their own candidates in the elections directly. So, and also it says that there should be no discrimination in the electoral rolls on the basis of religion, caste, race, sex, or any other kind of discrimination should not be allowed where electoral rolls are concerned. Where a person is fulfilling the qualifications of being an elector, he has to be on the electoral roll, whatever his caste, whatever his race, whatever his sex, whatever his religion. Okay, so this has to be very clear. So in the Representation of People's Act 1950, we have a Representation of People's Act 1950, 51, and we also have the Delimitation Commission of 1952. These are all the legal framework has been set up to ensure the free and fair elections in our country. So the People's of Representation Act 1950, it has the procedure for delimitation of constituencies. Delimitation of constituencies in the sense that according to the population, the constituencies of a particular area are demarked or delimited. So, the procedure for the delimitation was set up in this particular act, and under Article 82 of the Constitution, Parliament can enact delimitation act after every census. So, after every census, we are supposed to have a delimitation of each constituency where the population has increased, where the population has decreased, because you have to have the number of seats are allotted according to the population. So, obviously, after every census, you need to have the delimitation of the constituencies. So, the last delimitation was done in 2001 after the 2001 census, and the Parliament has amended that there should be no delimitation up to the year 2026. Up to the year 2026, there will be no delimitation of constituencies, and the last delimitation was done on the basis of the census of 2001. Sorry. So, allocation of seats in the Lok Sabha and the Legislative Assembly and the Council, the procedure for this has been laid down in the Representation of People's Act 1950. The procedure for preparation of electoral rolls has been enumerated, the qualification of voters has been enumerated, and in 2010, you must note 2010, in 2010, the voting rights have been given to citizens of India who are also living abroad. So, they can by ballot, by postal vote, they can also vote for their candidates in their particular constituencies. So, 2010 is an important year for you to remember that Indian citizens living abroad have also been given the right to vote for their particular candidates. Then after we had the Representation of People's Act in 1951. Again, a very important milestone act which had a lot of provisions for the conduction of elections. This particular act was introduced in the Parliament by the then Law Minister Dr. B.R. Ambedkar. Point to remember. So, this has conduction of elections to the house of both houses of Parliament and also to the house of the state legislatures. It also has administrative structure. What will be the structure of the administration when they are going to conduct elections? Who will conduct elections, at what level, which officer will be in charge of conducting the election? This has been enumerated in great detail. Qualifications and disqualifications of the membership of the house, those have also been enumerated in this particular Act of 1951. Corrupt practices and other offences have also been mentioned here, that any candidate who indulges in corrupt practices, what are the procedures for the disqualification of members, and what are the qualifications to become members, these have also been enumerated. So, for the Lok Sabha, you have candidates who are, if it is a constituency which has been earmarked for a scheduled caste person candidate, that particular candidate has to be a member of the scheduled caste, he has to be a member of that particular caste, and he also has to be an elector in that particular state. If it is scheduled tribe constituency, that the member who is, the candidate who is going to fight the election in that particular constituency has to be a member of that particular scheduled tribe and also a member or an elector of that particular state. And for any other Lok Sabha parliamentary seat, he has to be a elector in any particular state. For any other particular seat, he has to be an elector, so that he is eligible to stand for election for a parliamentary constituency. And disqualifications, these have also been mentioned. How is a person disqualified from becoming a member? If he is found guilty of any election offences have been enumerated, and if he is found guilty of any of those election offences, or if he has been found in indulging in any corrupt practices during his election campaign, during the whole process of elections. Then conviction for any offence resulting in imprisonment of 2 years or more. You are recently hearing of a very important case which is going on right now. A conviction of 2 years or more will lead to disqualification of membership. Conviction for promoting enmity or rivalry between two groups, or inciting any kind of enmity or hatred between groups of people during your election, during the election process or during your campaign. If you are indulging in such practices, you can be, and if you are found guilty, you can be disqualified from your membership. Another very important point which is in focus nowadays is that you fail to lodge an account of your election expenses with the Election Commission of India on time. There is now a specific time where you have to show the Election Commission that you have spent this much of money on the whole election process that you have gone through. And if you do not present this report on time to the Election Commission, they may be also disqualified, as their membership can be suspended. Also, people who have interest in government contracts, government works, these people, if it is proved that they have these kind of monetary interests, financial interests, they can also be, because the motto of coming into the parliament or to the state legislatures is to serve the people and not to indulge in financial activities. So they can also be disqualified. And if they have been dismissed, if they have been found that they have been dismissed from government service for corruption or disloyalty to the state, these are the two important conditions where they have been removed from government service. They have been dismissed from government service because they were found to be corrupt, or they have been disloyal to the state, or have indulged in some activity against the state. So these people can also be, if they are elected and found that these corrupt practices they have been indulging in, their membership can also be removed. And for practicing social crimes like sati or untouchability, things which are now not acceptable in our society, if they have been found guilty of such offences, social offences also, they can be disqualified as members. So in the 1951 Act, they have also specified what are the election offences. So what are the general type of election offences that a candidate can do? Basically, what the candidate, he is in the fray to win an election. So he may indulge in good practices, he may indulge in bad practices. So what are the bad practices that a candidate can indulge in? One is that he can offer any form of gratification to the voters to vote or not to vote. Sometimes you must have read many times in newspapers that money is being distributed, or liquor is being distributed, or some goodies are being distributed. So there are many things that candidates indulge in, or they try to lure the voters in their favor. And sometimes if they find that the voter is not in favor of him, so they try to lure your voter not to vote for the other candidate. So this kind of thing also candidates indulge in. So these are called the bad practices or the wrong practices, or they come under the election offences. Then the candidates, they also try to lure the candidates from withdrawing their candidature, or by giving them offering them whatever in kind or cash, or in some other form, to withdraw the candidature, so that their competition decreases and their chances of winning will increase. So that is also one of the election offences. Any direct or indirect inference to free exercise of electoral right. The person is free to go to the election booth and cast his vote. So anything in the way where you are interfering with the candidate, with the voter, that he is not able to freely go to the election place and vote. So this will also be called as an electoral offense. Then appeal to the elector to the voter on grounds of religion, race, caste, community, language. So these are the kind of allurements that the candidates give to people, that you are from my caste, you are from we both speak the same language, you're from my religion, so you have to vote for me. These kind of the candidates try to lure the people to their side on the basis of this. So this is also considered to be a election offense. The candidate is supposed to fight the election on the merits of what service he is going to offer, and not indulge in highlighting his religion or his caste or his race or his language. These are not to be done. Any activity which promotes hatred, propagation of social evils like sati or other social evils prevalent in our society, publication of any false statement, booth capturing, and obtaining any kind of government support is also going to be treated as a election offense. So these are all enumerated in the Representation of People's Act 1951. This is a important act for you, because still all these provisions are continuing, and there have been more and more amendments towards these particular. These are the fundamentals which have been laid down in the Act of 1951. So there's also a section on election expenses. So once it was found that some candidates were spending more money, the lesser financially strong candidates were spending less, so they were not able to convince the voters, and they were losing elections. So there was a felt need to have a particular election expense cut across all candidates, so nobody spends more, nobody spends less. So that way, this particular provision has made it fundamentally, it has made it very clear to the candidates that they have to follow some financial propriety where elections are concerned. They cannot go beyond a particular limit. He may be having the resources, but he cannot go beyond a limit to spend on his propaganda, whether it is posters, whether it is going on television, or any other mode of his electioneering. He cannot go beyond a particular limit. So according to section 77 of the 51 Act, he or his agent, the candidate himself or his agent, they have to give an account of expenditure in connection with all the expenses that they have incurred during the election process. And also a section 126 of the Act, section 126, section 126 of the Act says that 48 hours prior to the polling date, there should be no display of any election matter on TV. Okay, but this is the exceptions to this is social media and your print media and news and the news portals. So, but on television, because people indulge in debates, and they go on TV and aggressively promote themselves, and so this 48 hours before the polling, this has to stop, because these are the things which influence the mind of the voters. And section 126A, it prohibits, again this is 126A is also a very important provision of the Representation of People's Act, which says that it prohibits exit polls and dissemination of results during the voting period. So here you know that before 48 hours before the election process, there will be no exit polls, but once the time of the election voting is over, the exit polls are all over the media. So yeah, everybody knows about it, but that comes under Article 126A. Then there is another provision in this Act, that is donations. We all know that most parties do take donations from people, organizations, business, industries, and other like-minded people. So the Act also has set down certain principles of from who you can take donations and how much you can take. So it says that they have to submit to the Election Commission a list of all the donations that they have received, which are above 2,000 rupees. Above 2,000 rupees, all kind of donations have to be intimated to the election commissioners, the election commission of India. So they are now the parties are also eligible to get contributions from foreign companies defined under the Foreign Contribution Regulation Act of 2010. 2010 Act of Foreign Contribution Regulation Act of 2010. They can accept donations from foreign organizations as well. And in continuation of all these strictures that are and provisions that are available in the Act, there is also a provision that candidates have to report on their assets and liabilities. What assets do they have and what liabilities do they have? They have to assets and liabilities. Okay. So what are their assets and what are their liabilities? They have to file an affidavit. An affidavit says, it means that they are saying the truth and nothing but the truth. So, and if it is found wrong, that will be an election offense if it is found to be wrong on an inquiry. So they have to submit an affidavit saying that these are my assets, these are my liabilities, this is my educational qualification, these are my criminal records, and whatever history of the candidate, everything has to be submitted to the election commission. And after getting elected also, within 90 days, the candidate has to, if he is elected to the Lok Sabha, he has to give it to the speaker. And if he is elected to the Rajya Sabha, he has to give it to the chairman of the Rajya Sabha. And he has to file a declaration saying that these are his liabilities and these are his assets. So what happens is that after some time, after he is a member of parliament, suddenly there is a rise in his income or an unprecedented rise. So it leads to a lot of questions. So then you go back to what he filed at the time of his admission into the parliament. So then if there is an inquiry or if there is any kind of complaint, so this will be the base on which the inquiry will be held. So these are some of the provisions which have been made by this act to ensure that there is a lot of transparency in the selection of the candidates who are going to fight the elections. And the basis or the the thought behind this is that good, honest, hardworking, welfare oriented, people oriented people only fight the elections, and not all kinds of people with some criminal background, with some financial interests, and people who are not actually committed to the public cause. So with this in mind, this thought in mind, these provisions have been included in the Representation of People's Act. So what are the disqualifications? This act also has mentioned that on what grounds disqualification of candidates can be done. Section 8(1). If any person is convicted of an offence in the I.P.S. or Protection of Civil Rights Act of 55, Unlawful Activities Prevention Act of 1967, or Prevention of Corruption Act 1988, or Prevention of Terrorism Act 2002, anybody who is convicted, they will be disqualified. If he is convicted only of a fine, he will be dealt with a disqualification for 6 years. If he is been convicted of imprisonment also, then he will again continue for another 6 years of disqualification. And if he section 8(2) says that he'll be if he is convicted in any law like prevention of hoarding or profiteering, if he is found that he is indulging in financial irregularities and trying to hoard things, and also adulteration of food and drugs, again an important section, and Dowry Prohibition Act of 1961, again a very important section. If he is found guilty on these particular grounds, then also his candidature will be, his membership will be, he will be disqualified as a member of the parliament. And in section 8(3), if he is convicted for any offence or sentenced to imprisonment for not less than 2 years, 2 years or more, then also he will be, his membership will be suspended. A recent case you are hearing every day. So this is where there is a conviction of 2 years or more, not less than 2 years. So these are the provisions, important provisions of the Representation of Peoples Act 1951. Things you should know, because there are a few current affairs going on in a context of the elections, election process, disqualification of members, etc. So now we go to the next question. Which of the following statement correctly describes the fourth schedule of the Constitution? You know that we have 12 schedules to the Constitution. So which of the following is the fourth schedule? It lists the distribution of powers between the union and the state. It contains languages listed in the Constitution. It contains the three lists. It allocates seats in the Council of State, that is the Rajya Sabha. So here you need to know which schedule is having which provisions. Unless you know very clearly, you will not be able to answer this question, because all the answers look correct if you do not know the answer. But if you do know which schedule is what, then you will easily reach the correct answer here. So what is the first schedule of our Constitution? The first schedule is the names of the states and the union territories, territorial jurisdiction of the states, basically what is the Union of India. The second schedule has allowances, privileges and emoluments of the president and the governors and the Supreme Court judges and the state legislative members and speakers of the assembly, speaker of the Lok Sabha, chairman of the Rajya Sabha, and these important functionaries and their privileges and the emoluments are in the schedule 2. Schedule 3, the forms of oath and affirmations of the union ministers, who parliamentary, the election commission, members of parliament, the Supreme Court, everybody takes an oath once they are posted or once they are elected. They all have to take an oath or an affirmation showing their loyalty towards the Constitution and towards the work that they are going to perform. So these are the third schedule has the oaths and affirmations of very important officials or persons in the administration and the government. And the fourth schedule relates to allocation of seats for the states and union territories in the Rajya Sabha. As we all know, the Rajya Sabha is a representation of states. All the states and the union territories in our country are represented in the Rajya Sabha, and the seats allotted are generally done on the basis of the population of that particular state or the population of that particular union territory. So schedule 4 of the Constitution deals with allocation of seats in the Council of States, in the Council of State, that is the Rajya Sabha, that how many members of a particular state or union territory will be represented in the upper house of the parliament. Okay, so this is your answer. Going forward, I'll just give for your information, the fifth schedule, it has provisions related to the administration and control of scheduled areas and scheduled tribe areas. The fifth schedule, very important to remember the fifth and sixth schedules, which are very important from the UPSC preliminary point of view as well. Both are dealing with the very important tribal areas and scheduled areas of the country. The sixth schedule, it has administration of tribal areas in the states of Assam, Meghalaya, Mizoram and Tripura. Assam, Meghalaya, Mizoram and Tripura. Sixth schedule. Seventh schedule will have the three lists, the union list, the state list and the concurrent list. So you know that the union government legislates on the union list, the state government legislates on the state list, and the concurrent list both legislate, but in case of any conflict, the central law will prevail. Okay. The eighth schedule again very important. Many a time there have been questions on the eighth schedule of the Constitution. That is the 22 languages that are recognized by the Constitution. 22 languages have been incorporated in Schedule 8. Then we have Schedule 9. The state acts and regulates dealing with land reforms and abolition of the zamindari system. That is the 9th schedule. The 10th schedule provides for disqualification of members of parliament and state legislatures on grounds of defection. So the anti-defection law, and the 10th schedule where members are disqualified on the basis of them moving from one party to the other. The 11th schedule again very important. 11th and 12th both are important because they deal with local self-government. The powers, authority and responsibilities of panchayats is 11th schedule. Powers, authorities and responsibilities of municipalities in Schedule 12. So here you have your Schedule 1 to 12. Be very clear about them, and any question which relates to them, you will be able to answer. If you had known that the fourth schedule deals with allocation allocation of seats in the Rajya Sabha, you would have got this question right. Consider the following statements. The Constitution of India classifies ministers into 4 ranks. That is Cabinet Minister, Minister of State with independent charge, Minister of State and Deputy Minister. You must have heard all these names very frequently whenever there is a election and a new party comes to power. The first thing they do is constitute a cabinet of ministers. And in that you will find that there are some cabinet ministers. There are ministers who are going to help the cabinet minister, who are called the Minister of State. Then there are some important people who become Minister of State with independent charge. They do not have a cabinet minister above them. They hold that particular ministry. And you also have deputy ministers. The total number of ministers in the union government, including the Prime Minister, shall not exceed 15% of the total number of members of the Lok Sabha. So here you have to so which statement is correct? It is being asked which statement is correct. So here the Constitution classifies minister into 4 ranks. Here the point here is the Constitution. Does the Constitution mention that there has to be a Minister of State, there has to be a Minister of State for independent charge, they have to be a Deputy Minister, they have to be? No. The Constitution's Article 74 only says there shall be a Council of Ministers with the Prime Minister at the helm, or he'll be the head of the Council of Ministers. So this particular statement is wrong. This has come down over the years in the form of tradition, that we do not have all cabinet ministers. People with lesser abilities or smaller ministries, they need smaller terminology. So these terminologies have come as a tradition over the years, and now we have these particular ministers, deputy ministers, minister in charge of with the independent charge, and so on. And the total number of ministers in the union government, so this is a wrong statement. Then total number of ministers in the union government, including Prime Minister, shall not exceed 15% of the. So this was the 94th Amendment Act, where it said, you must have heard that before this particular amendment, you had jumbo cabinets to accommodate people from different religions, different castes, just different languages. So everybody was inducted, and this made the efficiency of the government go down because there were too many ministers and less allocation of work. So these used to be called jumbo cabinets, where you had 90 ministers, you had 100 ministers in working in the government. So this 94th Amendment said no, total whatever is the total number of members who have been elected, 15% should be the maximum. Minimum is 12. Maximum is 15% of the membership. So this statement is correct. So here we come to B only. This will be your correct answer. So B should be the option. A is not option. Constitution does not specify any ministers or the nomenclature of a minister. It only says that there will be a Council of Ministers headed by the Prime Minister. So go to the next question here. Article 371A and 371I were inserted in the Constitution to meet the regional demands of Nagaland, Assam, Manipur, Andhra Pradesh, Sikkim, Mizoram, Arunachal Pradesh and Goa. Constitution of India and the United States of America envisaged a dual policy of union and states but single citizenship. A naturalized citizen of India can never be deprived of his state citizenship. So they have, in this question, UPSC has jumbled up various topics. So you need to know some concept, you have to have some conceptual clarity about all the 3 concepts. The first one, Article 371A and 371 till 371I, A to I, they were inserted in the Constitution to meet the demands of Nagaland, Assam, Manipur, Andhra Pradesh, Sikkim, Mizoram, Arunachal Pradesh and Goa. Constitution of India and United States envisaged a dual policy of union and states but single citizenship. A naturalized citizen can never be deprived of his citizenship. So if we go to Article 371, basically if you go back to Article 27, Part 21 of the Constitution, you have special provisions for 12 states. The Constitution has provided special status for 12 states, the backward areas of these states which need more support from the government to develop. So these 12 states were identified as Maharashtra, Andhra, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Gujarat, Nagaland, Assam, Manipur, Goa and Karnataka. Not the whole state, but there were parts of every state which were identified as backward regions, which needed support, which needed funds, which needed plans, which needed developmental efforts to come on par with the other parts of the state. So these 12 states were identified by article, and in Article 27, these states were given special provisions. So they were all, these areas are also identified as cultural and socially and culturally very rich areas. Many of them are tribal areas, and there was a need to protect their own culture and social milieu. So these special provisions for these 12 states were identified. So though it was not in the original constitution, but these were inserted over time by subsequent amendments. Okay, so this statement will stand as a correct statement. Yes, by certain amendments, these areas were also included that they need to be specially identified for developmental purposes. The Constitution of India and United States envisaged a dual policy. So here dual policy, no, India had a single policy. India did not have a dual policy, and this we had union states, but we had a single policy for union state and single citizenship. Unlike America, where there is dual citizenship, the Americans are members of a particular state and also members of the American Union. So this statement stands wrong. A naturalized citizen of India can never be deprived of his citizenship. So how is citizenship acquired in India? You should know, and you should also read the Citizenship Act. Again, this is an important topic because of the numerous changes that have been happening to especially in the Northeast. So in India, citizenship can be got by birth. If you're born, naturally you get your citizenship, by descent, by registration and by naturalization. So these are the 4 ways in which you can acquire Indian citizenship. So by naturalization, what do we mean by naturalization? Ordinarily, a resident of India for 12 years. 12 years, he has to be a resident of India, and the last 12 months preceding his application, last 12 months before he has applied, and then 12 months continuously he has to show his residence here, and a total of 11 years in aggregate. And he also has to fulfill all the sections of the qualifications in the 3rd schedule of the Citizenship Act. If he fulfills all these conditions, then he is a naturalized citizen. But here it says a naturalized citizen of India can never be deprived of his citizenship, but yes, he can be deprived of his citizenship if it is found on inquiry that he has acquired this citizenship by any fraudulent means. He has not gone through the procedure properly. He has submitted false documents or anything fraudulently. If he has acquired the citizenship of the country, it can be his citizenship can be revoked, or he can be deprived of his citizenship. So statement 2 and 3 are wrong. Your statement 1 is correct. Which statement is correct? So there is one only. D option will be your correct option. Okay. So then we go to the next question. Which of the following provisions of the Constitution have a bearing on education? Education, again, there's a new education policy, a lot of changes happening in the education sector. So be updated on your education policy and education amendments and what are the changes that have occurred in the sector as well. So there are many sections of the constitution which have a bearing on education. It may be in a small way, it may be in a larger way, but there are. So, directive principles of state policy, the options here are directive principles of state policy, rural and urban bodies, 5th schedule, 6th schedule and 7th schedule. I have already discussed the schedules with you, so you can right away think about it. Directive principles of state policy, Article 41 says right to education. Article 41. It says right to education has to be given to all the citizens of the country. Then rural and urban bodies are supposed to secure land to build parks, to build schools, to build educational institutions, to build old age homes. These are all citizen centric activities that rural and urban bodies have to undertake. So here we have rural and urban bodies definitely have one of the tasks that they have to do is to build schools, primary schools, ensure that the children go to school. So this is also one of the bodies which is associated with education. Then you have the 5th schedule, the administration of certain areas and tribal areas. So definitely increasing the level of education in these backward areas is definitely one of the tasks of the that particular scheduled area or tribal area. 6th schedule, again I told you, administration of tribal areas in Assam, Meghalaya, Tripura and Mizoram. Again definitely there is an emphasis on increasing the education or enrolling children into schools. And then you have the 7th schedule. 7th schedule has the union list, state list and concurrent list, and obviously education is one of the important a very important part of the list. So you have all of them are having the portion of education as an important feature. So you have the answer 1, 2, 3, 4 and 5. Your option should be D. If you this particular question, if you know what the 5th schedule stands for, what the 6th schedule stands for, what the 7th schedule stands for, you will be able to easily answer this question. But if you do not know, you may get confused that maybe all of them are not correct. So you may go for the other options. So be very clear how to approach these kind of questions. The fundamental objective of the Panchayati Raj system is to ensure which among the following. The Panchayati Raj system, it is the local self-government from the village level to the district level. So here, what is the, why was Panchayati Raj envisaged for our country, and what is the aim of Panchayati Raj? Have we been able, how the whole progression of the Panchayati Raj system, and have we ensured that it has succeeded in our country? Please do go through that also. The people's participation in development, the options, political accountability, democratic decentralization, financial mobilization. But here the main thing that you have to focus on is the fundamental objective. What is the fundamental objective of Panchayati Raj? Why do we need to have local self-government? We already have a central government, we already have a state government. So why do you need another level of government? The Panchayati Raj system in our country, the main basic aim was to get people to get involved in their own development. Village panchayats, members of the village are all members of the village panchayat. They all get it together, plan, mobilize funds, and they get to develop their own projects. So here you have people's participation in development. Definitely this option should be there. Political accountability. Yes, many the village panchayats are generally directly elected. They have an accountability, but this kind of political accountability that we are talking about at the in the union at the union government level, the accountability that if a no confidence motion is passed, then the government falls. This kind of political accountability that we are talking about, this does not happen in Panchayati Raj institution. Democratic decentralization, one of the important and very, very specific aim of Panchayati Raj was to have democratic decentralization. Democratic in the sense that it is people, for the people, by the people, of the people, at the village level to the taluk level or the zonal level. So here you have democratic decentralization, that it is not for only the central government or the state government to envisage plans for a particular village. It is for the people at that particular level to have their own developmental plans. So this is definitely in there. And financial mobilization, that is, it is not the fundamental objective. It is one of the objective, but not the fundamental objective. You have to be very careful in uh, eliminating every or in this, all of them look correct. They all look correct, but here only 1 and C are the options, because we are going only to the fundamental objectives of Panchayati Raj and not all the objectives of Panchayati Raj. We are going here for the principle, the fundamental. We were talking about the fundamental is decentralization and also people's participation. These were the two aims of the Panchayati Raj system in India. With reference to part 4 of the constitution, which statement is correct? Part 4 deals with, part 3 deals with fundamental rights, part 4 deals with directive principles of state policy. They shall be enforceable by courts, they shall not be enforceable by any court. The principles laid down in this part are to influence the making of laws by the state. So as we know, directive principles are not enforceable by a court of law. So your first statement is directly not correct. He is saying which of the following statements is correct. So 2 is not correct. They are not enforceable is correct. And the principles laid down for making, they are guidelines. They show the light to the lawmakers that you can make laws on these particular subjects which have been enumerated. So they are their view. You have labor laws, you have prevention of children from working, you have equal pay for equal wages act, you have so many other maternity benefit act, and so many other acts which have been formulated based on the directive principles of state policy. Directly lifted from state policy, you have these particular acts which are welfare oriented, which are citizen oriented, citizen centric, and they also aim at a socially equitable, economically equitable, politically equitable, and a welfare society. So your option 2 and 3 are correct. So you have here option 2 and 3 will be D. This will be your correct answer. Under the Indian Constitution, concentration of wealth violates. Here UPSC will be trying to gauge how your concept is clear or not, whether you have a grasp of the subject. So when you say that it violates the concentration of wealth, it violates what? So you have to be very careful in eliminating the particular. So here you say right to equality. You may think that, oh yes, he has more wealth and I have less, so this is violating my right to equality. But here the basic fundamental idea is that you work as a laborer, so you get this much wealth, and somebody is an industrialist, so he has that much wealth. He has also worked hard, you have also worked hard, but this is not what what is envisaged, that equality is everybody has the same kind of wealth. No, equal pay for equal work, you get what you have worked for. So here the right to equality does not mean that everybody has to have equal share of the wealth or equal share of the means of production or equal share of the productivity of the country. No, it means that you have a right to your own share of the wealth of the country for what you have contributed toward the productivity. Directive principles of state policy. There is directive principles of state policy which says that the state should strive for the ownership and the control of the material resources of the community should be so distributed that it is for the common good. That is 39B. Then you have section 39C in the directive principles of state policy which says there should be no concentration of wealth. There should be equitable distribution of wealth. So these are the two directive principles of state policy which says that there should be more equitable distribution of the productivity of the country. Right to freedom, also you have the freedom to choose your profession, you have to choose your religion, you have to choose where you want to stay, you have freedom to move. So this freedom will not be, it will not violate your concentration of wealth. The concept of welfare state is where the government ensures that all the wealth of there are steps taken by everyone or the governments to ensure that there is the welfare of the citizens is paramount. So here under the Indian Constitution, concentration of wealth only violates your directive principles of state policy directly and not the other three. So you have to be very careful here because this is a relatively easier answer because you do not have A and B, B and C, C and D. So here you can very clearly know that directive principle of state policy has 39B, 39C, which says that there should be equitable distribution of wealth, there should be no concentration of wealth, and there should be, everybody should have a fair share of their of the resources of the country. So directly you have to go to option B and say that this is the correct answer. Which part of the Constitution of India declares the ideal of welfare state? Sometimes UPSC, it comes up with very simple looking questions, direct questions, which are very few and far in between. But if you have this direct question which seems to be clear, grab it, because it says which part of the Constitution declares the ideal of welfare state. It is not the fundamental rights, not the preamble, not the 7th schedule, it is the directive principles of state policy. Clearly, Article 38 states that to secure a social order for promotion of welfare of the people. So welfare of the people is here. Yes, welfare of the people is there in fundamental rights as well, in the preamble as well, in the 7th schedule as well, but the answer will be directive principles of state policy. So today in this series of previous year's questions related to polity and governance, I have covered 10 questions important, which I thought I randomly picked up from over the years, the questions that have been posed by UPSC. And in this series will continue where I will be asking you to practice more and more previous year's questions, because that is the best way to revise. And revision is the best way to revise is to do previous year's questions, because it not only covers the whole syllabus, it also ensures that you get your concepts clear. So that's all for today. I will see you very soon with the next. Thank you so much.